Welcome to The Explainer. Today, we are diving into a really fascinating story from India. It's all about a constitutional power that was so huge, so potentially world-altering, that the country's highest court had to invent a completely new rule to keep it in check. So let's kick things off with a real head-scratcher, a paradox that sits right at the heart of many democracies. How do you let a country's constitution, its main rulebook, change with the times without also giving someone the power to just tear up the whole book and start over?
And this is where our story really gets going. It all starts with a single tool, something called Article 368. Now, this is the part of India's constitution that gives Parliament the power to amend it. A tool for progress, for sure, but as we'll see, one with massive potential for change.
Okay, so how does this amendment power actually work? I mean, it's not like just passing any old law. It's a much bigger deal. Let's take a look at the actual procedure.
You see, it's this really tough four-step process. A bill to change the Constitution can start in either House of Parliament. That's pretty standard. But then it has to get through this very specific, very difficult voting process. And sometimes it even needs a thumbs up from the states themselves. Oh, and the president's approval? Absolutely mandatory.
The real key, the thing that makes this so hard, is something called a special majority. And this is basically a double lock. First, you need more than half of the total number of members in the House to be in favor. And second, of the members who are actually there and voting, you need a whopping 2/3 majority. So yeah, this is designed to be tough to make sure any change has a really strong consensus behind it.
So, with the rules of the game set, what happened next? Well, you get this massive, decades-long power struggle, a real constitutional tug-of-war between the lawmakers in Parliament and the judges in the Supreme Court. And it was all about one single question. Is this power to amend totally unlimited? Just look at this timeline. It's this incredible back and forth, like a high-stakes chess match. First, the court says, yep, Parliament's power is absolute. Then, years later, it completely flips and says, nope, some things are off limits. Parliament fires back with its own move, and then the court comes up with this brilliant, totally game-changing idea.
Let's break that down a bit. In 1951, the Supreme Court basically gave Parliament a total green light. They said, go ahead, you can change anything, and that included the fundamental rights of citizens. But then, fast forward 16 years to 1967. A whole new bench of judges looks at the issue and slams on the brakes. They declare that those same rights are sacrosanct. They're sacred and totally off-limit. The court's argument was pretty clever. They said Article 368 just lays out the procedure for an amendment. It doesn't grant limitless power. So how did Parliament react? Well, they definitely didn't just take this lying down. In 1971, they passed something called the 24th Amendment, which basically wrote into the Constitution itself that yes, they absolutely did have the power to amend anything they wanted to. And this is where the story gets just wild. This whole debate, this huge constitutional crisis that was going to define the future of power in the world's largest democracy, it all came down to this: a 7-6 vote, a razor-thin majority of just one single judge. This brings us to the climax, the legendary Kesavananda Bharati case of 1973. Here, the court pulls off this absolutely brilliant compromise. On the one hand, they said, okay, Parliament, you win. You can amend fundamental rights. But then, they added a massive but. They introduced a profound, completely new limit that changed everything. So what was this ingenious solution? It was an idea that, and this is the crazy part, you won't actually find written down anywhere in the text of the Constitution itself. It's known as the Basic Structure Doctrine. Think of it like this. The court basically said, Parliament, you can renovate the Constitutional House, you can change the paint, move the walls, add a new room, but you cannot knock down the foundation. You can change the laws, sure, but you can't destroy the core identity of the Constitution.
So what are these foundational walls? Well, they're the big ones, the core principles. Things like the supremacy of the Constitution itself, the idea that India is a democracy, the separation of powers between the government branches, and even the court's own power to review laws. You know, making sure the referee can't be kicked out of the game.
There's this amazing quote from a later case that just nails it, that perfectly captures the spirit of this whole idea. It says, a creature cannot rewrite its own creation document to become the master. In other words, Parliament was created by the Constitution, so it can never ever put itself above its own creator. And the Minerva Mills case in 1980 was really the final word on the matter. Parliament had tried one last time to give itself unlimited power. but the court struck it down, cementing the basic structure doctrine once and for all. They even said that things like judicial review and limits on Parliament's power were themselves part of that basic structure.
All right, so what does all of this mean today? Let's talk about the legacy of this doctrine and the incredible balance of power it created in India.
The big takeaway from this whole saga is this really clear, really important distinction. The doctrine makes sure Parliament's job is to be an amender of the Constitution, not its destroyer. They're a custodian, not an architect who can tear the whole building down.
And you might be asking, okay, why is this so important? Well, think of it as a constitutional emergency brake. It's a fundamental safeguard that makes sure no government, no matter how powerful or how big its majority is, can use the letter of the law to destroy the spirit of the law and, dismantle democracy from the inside out.
And that leaves us with one final and I think really fascinating question. This powerful safeguard, this ultimate guardian of the Constitution, isn't actually written down anywhere. It's a living, breathing idea defined by judges on a case-by-case basis. So the big question is, who ultimately gets to decide where those constitutional red lines are drawn?